It gives me immense pleasure to welcome you all. We work closely with AP and Telangana governments for policy formulation, advocacy, and representing on various issues on behalf of Indian and American companies for trade related matters. We work closely with US Consulate General Hyderabad as well on issues related to visas, trade barriers, and other prominent matters. Recently, we have been organizing a webinar series on navigating cross-border business disputes from courts to arbitration and insolvency problems. Today, in this series, this is the third webinar, and in this series, we are going to discuss complexities of cross-border insolvency and legal frameworks, challenges, and various strategies. We are thankful to Chandhiok and Mahajan advocates and solicitors for their support and for being the knowledge partners. I would personally like to extend a very special welcome to Ms. Mahima Singh. She's the partner at Chandhiok and Mahajan Advocates and Solicitors. A little more about Ms. Mahima Singh is um, she's a she is a partner, as I told you earlier, in Chandhiok and Mahajan Advocates and Solicitors, which is a full-size law firm, full-service law firm with offices in Delhi, Mumbai, Hyderabad, and Bengaluru. She is a restructuring and insolvency specialist. She provides all-round legal support services to creditors, debtors, and resolution professionals, liquidators, investors, and other stakeholders on a wide array of issues related to debt restructuring, resolution, and liquidation under Indian R&I laws. We are really indeed privileged to have her today to be amongst us and help us with this session. She has advised many clients in various complex cases of insolvency earlier. Apart from R&I, she has worked on matters relating to oppression and mismanagement, winding up commercial and contractual disputes, arbitration, and competition law. Well, her profile is totally 3 pages. I'll stop here. And with these words, I wish you all a very productive and fruitful session. Mahimaji, all over to you.
Very good evening to
Thank you, ma'am. Thank you so much. Yeah, please, Mahimaji.
Firstly, thanks a lot, Sridevi Garu and Shika Garu for inviting us and allowing us to be a part of this collaborative effort. It is our pleasure indeed to be knowledge partners in this webinar. I have already, my introduction has been very graciously provided by Sridevi Garu, so I will not spend time on that. And we can straight away head to the presentation. As the participants would be aware that this was a 3-part session in which the first session dealt with cross-border disputes and the issues which are faced and how do we address those. The second was focused on arbitration. And the third one, which is the subject matter of today's session, is about cross-border insolvency and restructuring issues. What is the current legal framework? What is a proposed framework, and what are the challenges or concerns going forward, and how do we address them? Please just move to the next slide. So very briefly, I'll introduce Chandhiok Mahajan. We are a full-service law firm. We can go to the next. So yes, we are a full-service law firm, and we provide legal services across a range of practice areas, which includes general dispute resolution and arbitration, competition and antitrust, restructuring and insolvency, corporate practice, capital markets, and data privacy. As far as the restructuring and insolvency practice is concerned, we are recognized for our in-depth, practical and thorough understanding of the entire gamut of restructuring and insolvency practice. The USP of our practice is the integration of advisory services with dispute resolution services, as a result of which we cover the entire spectrum of the R&I services. We have advised various creditors, resolution professionals, liquidators, investors on various kinds of contentious and non-contentious matters, both insolvency resolution as well as liquidation. And this includes both IBC and non-IBC restructuring work. So now coming to the subject matter of today's session. So basically, first, I would like to give the audience a brief background of the Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code was introduced in 2016, and it marked a paradigm shift in the insolvency regime, which is prevalent in India. Prior to the enactment of the Insolvency and Bankruptcy Code, there were various other laws and the legal provisions governing insolvency and winding up of companies were scattered across various enactments. So we obviously had winding up under the Companies Act. We had SARFACI. We do have SARFACI still. Then we had the RDDB Act. So while the provisions were there in different statutes, there was a widely felt need that India needed a comprehensive legal framework for not just liquidation and winding up of corporate entities, but also a legal framework which could ensure their revival and resolution as a going concern. And that led, after a lot of discussions and deliberations and the report submitted by the PLRC committee, the parliament eventually enacted the code in December of 2016. And that marked a paradigm shift in the regime which covered restructuring and insolvency of corporate entities and individuals. So we'll go to the next slide. So as I said, the IBC, the Insolvency and Bankruptcy Code, it came into force in December of 2016. Now, what the IBC did was this. Prior to the enactment of the IBC, the only way to, outcome which was there for a company which was distressed was either to approach the PIFER in SICA, or you could go for a liquidation and winding up of the company under the Companies Act. There were other modes of recovery, for instance, under the RDDB Act for the banks, and also basically enforcing a security interest under the SARFACI Act. What the IBC did was to introduce a two-stage process. The first is that a company which is distressed and has defaulted on its loans can be admitted into a process which is called, in short, the CIRP, and it stands for a Corporate Insolvency Resolution Process. Now, what happens in a corporate insolvency resolution process is that a company, the effort is to restructure and revive the company as a going concern while ensuring its continued business operations. If the resolution, that is the reorganization process, fails, then the company is headed into liquidation. So this was a very significant shift, because instead of having the company slip into liquidation straight away by way of a winding up proceeding, the companies got a new, at least the companies which could be resolved and revived, got a new lease of life because they got the chance to be revived and restructured by way of a CIRP process. Now, how does a corporate insolvency resolution process start? A corporate insolvency resolution process under the IBC can be started by filing an application before the National Company Law Tribunal, and an application against a company for initiation of CIRP can be filed in the jurisdictional NCLT where the registered office of the corporate debtor is situated. So, for instance, if the registered office of a corporate debtor is in Hyderabad, then in that case, if I as a creditor wish to initiate the insolvency resolution process, I have to approach the Hyderabad bench of the NCLT, and I cannot approach any other bench such as Delhi, Bombay for initiating the corporate insolvency resolution process. Now, who can file a CIRP application? Number one, it's a financial creditor. Now, financial creditor can file an application under Section 7 of the IBC. And the financial creditors are essentially those. There is a specific definition in the IBC, but financial creditors, generally explained, would mean creditors to whom a financial debt is owed. That is where a debt is owed which has the consideration for time value of money. The second category of creditors who can file a CIRP application are your general operational creditors. So these include typically the vendors, suppliers, but the definition in the code also includes employees and government dues within the ambit of operational debt. The third category of CIRP applications can be filed by the company in default itself, which is called a Section 10 filing. So essentially, there are three ways in which the CIRP of a company can be started. Now, very briefly, we'll go to, I'll just like to give the audience a very brief overview of what really happens in a resolution process scenario, and then come to the subject matter of today's session, which is the cross-border issues. Now, once the company, the debtor company, is admitted into an insolvency resolution process, the first thing which happens is that the management of the corporate debtor gets suspended. And this is a striking departure from the earlier regime, when the management would continue to be in control of the company, even though it was undergoing some form of restructuring process. And this is known as a situation where the creditor takes control of the company, and hence it is called a creditor in control regime, which is similar to UK model. So yes, so coming back to the initiation of CIRP, once the CIRP is initiated, the first thing which happens is the management of the company stands suspended, the board of directors, their powers stand suspended, and the management of the company shifts to an insolvency practitioner who is referred to as interim resolution professional initially, and subsequently gets either confirmed or replaced by another resolution professional. Now, the management of the company shifts with the IRP and later the IRP. The IRP and the IRP have to function under the overall supervision and control of the creditors committee, which is also generally referred to as the COC, Committee of Creditors. Now, what about people who have claims against the corporate entity? Now, creditors who have any claim, be it a financial claim or an operational claim or any other claim against a company in default, which has been admitted into CIRP, can file their claims before the IRP or RP. And there are specific forms which are provided in the relevant regulations, which are referred to as CIRP regulations. And those forms can be used for the purposes of submission of claims by creditors. And these claims need to be as on the insolvency commencement date for each company. Now, those claims, there's a detailed process, and I won't take too much time on that. But what happens is that when the creditor, so for instance, if there's an operational creditor who has a claim of, say, 10 crores on a company which has undergone CIRP, then that operational creditor is required to file the claim in a particular form with the IRP-RP. And if that claim is found to be verifiable as per the records of the company, then the IRP will admit the claim, and that creditor will be included in the list of creditors of the corporate debtor. Now, while the CIRP of the company is undergoing, the IRP-RP he is duty bound to run the company as a going concern, ensure its continued business operations, etc. And all of this is being done under the overall supervision and control of the creditors committee. Now, the key function and the role of the RP is to invite resolution plans, which are essentially plans submitted by interested bidders for the revival and the reorganization and restructuring of the company. If and there's no limit. So, for instance, if the company has been admitted into CIRP, typically the RP will invite expressions of interest. Whoever is found, whichever bidder is found to be eligible as per the eligibility criteria that is set by the creditors committee, is then invited to conduct a due diligence of the corporate debtor. And once the due diligence is conducted, then a bidder who is interested in submitting a resolution plan can submit a resolution plan. The resolution plan, if it complies with the mandatory requirements of the code, has to be placed by the RP before the creditors committee. And if the creditors committee approves a resolution plan, then the approved plan is placed before the adjudicating authority, which is the National Company Law Tribunal, the relevant bench of the NCLT. And after that, if the NCLT also approves the resolution plan, then the resolution plan is set, the resolution process is said to have successfully concluded, marking the end of the CIRP. However, if no resolution plan is received, or if a resolution plan is received, but it does not receive the approval of the COC by 66% at least, or If it is approved by the COC, but it is not approved by the NCLT for some reason, then it marks basically the CIRP is said to have not concluded successfully, and the ultimate fate of the company is then liquidation, for which there is a detailed chapter which deals with how the liquidation of the company will happen. So this is a very, very brief overview of how the resolution process operates under the provisions of the Insolvency and Bankruptcy Code. Now, coming to the cross-border aspect of insolvency, cross-border aspects and issues which arise in the insolvency context. We'll go to the next slide. Now, what is a cross-border insolvency issue, and when can it be said to arise? Now, a cross-border insolvency issue can arise when an Indian company has any liabilities or assets or operations in a foreign country. Vice versa, a cross-border issue can arise, insolvency issue can arise in a situation where a foreign company has liabilities, assets, or operations in India, within the Indian jurisdiction. So these are the two broad buckets of cross-border insolvency situations which can arise. Now, going into a little bit more detail and some examples. So the various kinds of situations which can potentially give rise to a cross-border insolvency issue is, number one, for instance, I as a creditor who's based in India can have liabilities or dues which I owe to a foreign entity or individual. So there is a cross-border element involved in this case. Likewise, there could be an Indian company which has debts owed to it by any foreign entity or individual. Then the second kind of case where cross-border insolvency issues can arise is when any corporate entity or LLP or any other entity has any offices or branches or its business operations or its plants and facilities or its customers in a foreign jurisdiction or in an Indian jurisdiction. So that can also potentially be a source of a cross-border insolvency issue. Excuse me. Then, of course, there can be companies which have subsidiary companies, associate companies, or other group companies which are situated across jurisdictions, which we typically see in case of multinational companies. And this is pretty much become the norm. The companies have a global footprint. So this is also one area where cross-border insolvency situations can arise. Then there comes the category of of an Indian, for instance, having cash balances or investments in a foreign bank account or in a foreign entity. Likewise, foreigners can have their investments, loans, or they can be holding cash in Indian bank accounts or Indian companies. And finally, we are all aware that there are various agreements, maybe with vendors, suppliers, we can have licenses which are cross-border in nature. And that is also a potential situation in which an insolvency-related issue can arise. Now, just because we are right now focusing on foreign, what are the kinds of issues that probably Indian companies or Indian entities can face in a cross-border insolvency situation? It is relevant to look at what are the kinds of foreign liabilities and foreign assets which Indian companies may have. And this is sourced from the report of the Cross-Border Rules and Regulations Committee, which was constituted by the government. So I will very quickly run through this. This is just for the reference of the audience. So the kind of foreign liabilities that an Indian company can have can be of four kinds. It could be a foreign financial liability, a foreign operational liability. There could be a foreign judgment creditor or foreign statutory dues. Foreign financial liabilities typically would include loans which are either secured or unsecured. There could be external commercial borrowings. There could be foreign currency convertible bonds or other kinds of bonds which are issued by foreign persons. Or there could also be liabilities which are arising out of guarantees which are provided by a debtor company to foreign people. Foreign operational liabilities would be our usual trade payables or wages and salaries. Or there could be some other operational liabilities or goods that we purchased but that's been partly paid. So these are the various types of foreign operational liabilities that can arise. Then foreign judgment creditors essentially includes either a financial or operational obligation which arises out of any judgment or arbitral award which has been passed in a foreign jurisdiction. And finally, the foreign statutory liabilities could be statutory liabilities, for instance, social security liabilities, or if there are any payments which are mandated under any statute or any other tax law, then that could fall in the category of foreign statutory dues. Likewise, coming to foreign assets, these could be in the nature of tangible assets in a foreign country, for instance, plant and machinery, or if an Indian company holds an office space, or work in progress assets, etc., which are situated in a foreign country, then these are tangible assets which are located in a foreign country. And then there would be movable assets like inventory, furniture, etc., which would also fall in the category of tangible assets, foreign tangible assets. Then we have intangible assets in a foreign country, and these would include licenses, intellectual property rights, or there could be supply agreements, etc. Then loans and advances which I have given to a foreign debtor, which an Indian company has given to a foreign debtor, would also fall in the category of a foreign asset. Then an Indian company can hold foreign investment. It could be either investment in foreign financial assets and instruments, or it could be its shareholding in subsidiaries, associate companies, and joint venture companies. Then there are trade receivables, etc., that an Indian company may be owed by foreign customers and other parties. And then finally, the cash and cash equivalents which an Indian company holds in any foreign jurisdiction would also fall in the category of foreign assets. Now, coming to the current legal framework which governs cross-border insolvency in India. Now, at the very outset, I would like to inform the audience that the IBC as it currently stands, there are only two provisions, that is Section 234 and 235, which are more in the nature of enabling provisions, which deal with cross-border insolvency situations. Now, coming first to Section 234 of the IBC. Section 234 of the IBC, and that is there on the screen for the benefit of the audience, and I will read it. Section 234 of the IBC deals with reciprocal arrangements with foreign countries, and it provides that the central government may enter into bilateral treaties with the government of any other country to enforce the provisions of the code. So basically what this means is that the government of India can enter into reciprocal arrangements or treaties with foreign jurisdictions for the purposes of enforcement of the provisions of the code. And the other clause of Section 234 provides that the central government can notify the enforcement of the provisions of the code in respect to any assets or properties of the corporate debtors or debtors including personal guarantors in countries with which the central government has entered into reciprocal arrangements. So that's Section 234. Then comes Section 235. Right. Now, Section 234 actually follows and flows from Section 235 flows and follows from Section 235, and it enables sending a letter of request to any foreign country in certain cases. Now, what it provides is that in countries with which we have reciprocal arrangements, which are governed under Section 234, and in that case, if there is an insolvency resolution process or a liquidation or a bankruptcy proceeding which is going on, then in that case, the resolution professional or the liquidator or the bankruptcy trustee can approach the NCLT and request that any evidence or action that needs to be taken in respect of such assets which are located in these foreign countries with which we have a reciprocal arrangement, that access be provided to these assets. And the NCLT, upon receipt of the application, and if it is satisfied that yes, there is a requirement of evidence or action and which is located in a foreign jurisdiction, then it is the NCLT which can issue a letter of request to a foreign court or to a foreign authority to deal with such a request. So these are the only two provisions which are currently there in the IBC, which deal with certain aspects governing cross-border insolvency. And there is a widely felt need, and there's a lot of discussion that these two provisions are not enough, given the scale of cross-border, the cross-border activity which is happening even in India. 234, 235 are there, but they are not enough. They are merely enabling provisions, and there is a widely felt need for having a comprehensive framework which deals with various aspects of a cross-border, insolvency situation. So now, coming next to the ancestral model law on cross-border insolvency. Now, the ancestral model law on cross-border insolvency is actually a globally accepted framework, a legal framework, which contains various provisions dealing with various kinds of cross-border insolvency issues. The ancestral model law, I would like to clarify, is not binding on all the countries. As the name suggests, it's a model law which enables the country and in fact gives the discretion to the countries to adopt it and enact laws drawing the principles from the model law while making carve-outs and exceptions and modifications which may be suitable to their respective jurisdiction. And hence it is called the model law. Be that as it may, as we speak, as on date, the cross-border model law, ancestral model law, has been adopted in more than 60 jurisdictions, including countries such as USA, UK, Japan, and also Singapore. India so far has not adopted the ancestral model law on cross-border insolvency. And we'll come to that. But just very briefly, that if the model law is adopted along with certain modifications and carve-outs which are specific to an enacting country, it is believed that there are various advantages to the adoption of model law, and these include increase in foreign investment, providing flexibility in dealing with cross-border insolvency issues, at the same time allowing protection of domestic interest by way of carve-outs and modifications, then giving priority to domestic proceedings, and also providing a mechanism for cooperation and coordination when there are insolvency proceedings pertaining to a debtor which are either ongoing or have been initiated at the same time or parallelly in different jurisdictions. Now, there are 4 main principles of cross-border insolvency under the model law. The first is access. Now, the purpose of access is so that foreign insolvency practitioners and foreign creditors can get access to the domestic courts, and they are enabled to participate in and take part in the insolvency proceedings that may be pending against a debtor company in India. Recognition is the second important principle of cross-border insolvency, and the principle of recognition essentially means that a foreign proceeding and the remedies and the reliefs which are available in a foreign proceeding are recognized by the domestic courts, applying the principle of recognition, and the relief can be provided depending on whether the foreign proceeding is either a main proceeding or a non-main proceeding. Now, the audience would be wondering, what is the how do we determine whether a particular proceeding is a main insolvency proceeding or a non-main insolvency proceeding? And that is where the concept of COMI comes in and is very important. COMI stands for Center of Main Interest. Now, the center of main interest of a company is basically determined. Primarily, the presumption is that where the registered office of a corporate debtor is situated, that is where the COMI of a particular insolvency proceeding is situated. COMI of the debtor is situated. However, this is a rebuttable presumption, and there are various other aspects that one can go into to find out whether or not the COMI is actually situated in the same place as where the registered office of the debtor is situated. Now, if it is determined that the COMI is not situated in a particular foreign jurisdiction, but the debtor has an establishment there which is non-transitory in nature, then the foreign insolvency proceeding will be recognized as the non-main proceeding. And depending on whether the proceeding is a recognized as a main proceeding or a non-main proceeding, that would govern the nature of reliefs which are granted by the domestic courts. The third main principle is of cross-border, of the ancestral model law, is cooperation. And cooperation essentially involves cooperation between the domestic courts and the foreign courts, and also between the insolvency practitioners who are in control of the domestic proceeding and the foreign insolvency proceeding. Coordination, which is similar to cooperation, is when there are concurrent insolvency proceedings which are pending or which may be pending in maybe 2 or more than 2 countries. it becomes important, given the interconnectedness between the insolvency proceedings, that there is coordination between the insolvency practitioners and also between the courts in which these insolvency proceedings are on. So these are the four main principles of the ancestral model law: access, recognition, coordination, cooperation, and coordination, ARCC. Now, coming to India, as I mentioned, so far, India has not adopted the ancestral model law on cross-border insolvency. And I will now come to the various reports which have been commissioned and have been submitted recommending adoption of the model law on cross-border insolvency. The first such report was submitted by the Insolvency Law Committee in October of 2018. This committee was in fact constituted by the Ministry of Corporate Affairs to submit its recommendation, its views and recommendation on whether the model law should be adopted in India, and if so, in what form. Now, the ILC report, and this report is available on, it's available in the public domain. It intensively examines the model law, the various aspects of the model law, including the underlying principles, what are the issues that need to be covered, etc., and the Indian condition. And ultimately, in the ILC report, there is a recommendation that yes, we need to adopt the model law as part of the IBC. However, this has to be subject to certain modifications which are suitable to the Indian context. What the ILC report also did was that there is a draft law which is referred to as Part Z, which is recommended to be incorporated within the IBC itself. Because as we discussed earlier, currently there are only two provisions in the code, which is 234 and 235, which are merely in the nature of enabling provisions, which deal with certain aspects of cross-border insolvency, and that too to a very limited extent. What we need is a comprehensive legal framework which deals with multiple aspects of cross-border insolvency, and that is what is intended to be provided. It was recommended to be provided in the form of Part Z in the ILC report of 2018. Subsequently, there was another committee which was constituted, which is the Committee on Rules and Regulations Governing Cross-Border Cases. Now, this is referred to as the CBIRC. So, the purpose, the scope of this committee was essentially to recommend measures in the form of rules and regulations that would help to operationalize the adoption of the cross-border, the model on cross-border insolvency, subject to the modifications as suggested by the ILC committee. So what is the measures that we can take towards adoption of the ancestral model law? The CBIRC has also submitted its report, and that report in fact contains draft rules, regulations, and certain notifications that would enable us, as and when we adopt the model law, it will enable the implementation of Part Z, however, with certain amendments. The CBIRC report also deals with certain aspects of group insolvency, but that is not the remit of today's presentation. So we will not go into that. But essentially, it is the position is clear that both the ILC report as well as the CBIRC report have recommended the adoption of the model law on cross-border insolvency, subject to certain modifications and carve-outs which are suitable to the Indian condition. So now, coming to the case law, and the reason why we have this section is critical, because so far India has not adopted the ancestral model law. We have two committee reports which have recommended the adoption of the model law. However, till date, while we understand from information available in the public domain that it is being considered and discussed by the government, so far the model law, the ancestral model law, and the Part Z as recommended by the ILC report has still not been adopted and enacted, and therefore there is a gap, and that is where the judiciary has stepped in, the NCLT and the courts have stepped in to fill in the gap as and when the need has arisen. Now, we will in the next few slides focus on the important cases which have arisen in a cross-border insolvency context. Now, in the initial years, that is in 2017 itself, one of the first questions which came up before the courts was whether a person, a foreign person, a foreign entity or a foreign company who is resident outside India would qualify as a person for the purposes of the code and can file a claim as a creditor under the code. This issue came up in Macquarie Bank versus Shilpi Cable, and the Supreme Court held that the meaning of the term person in Section 2, subsection 23 of the IBC also includes persons outside India. So it is today it is very clear that a foreign creditor can also file a claim in insolvency proceedings which are situated in India. That's a settled position now. Now, the next important case is Tanvik Ghana, where the NCLT was faced with a Section 7 proceeding in which the creditor had relied on a decree which was passed by a foreign court. So this was defended. It was sought to be defended by the debtor on the ground that this foreign decree cannot be taken note of because execution of the foreign decree has to be by way of a certain procedure, and the NCLT cannot take this foreign decree into cognizance. However, the NCLT said that we are taking cognizance of this foreign decree in Section 7 proceedings as a proof that there is a debt which is outstanding to the creditor. So this was also a significant ruling, and this was also a ruling which came in the initial days of the IBC in the year 2017. Now, the next case, which I think almost all of the audience would be aware of, is the Jet Airways case. Now, we all know that in around April of 2019, Jet Airways, due to its extreme financial difficulties, it had to suspend its operations. And eventually, the company was admitted into corporate insolvency resolution upon filing of the Section 7 application by a financial creditor. Now, while the insolvency proceedings of Jet Airways started in India, there was also a parallel proceeding, insolvency proceeding, which was initiated in the Netherlands. Now, when the Jet Airways went into CIRP in India, then the Dutch trustee had approached the NCLT seeking recognition as in the Indian proceedings, in the Indian insolvency proceedings. Now, his application was rejected by the NCLT. The matter went up to the NCLAT, the appellate tribunal, and very interestingly enough, and this was a significant judicial intervention where the court encouraged both the resolution professional of Jet Airways as well as the Dutch administrator to work together and arrive at certain agreed terms which were based on the principles of cooperation and collaboration. And eventually what came out as a result of these negotiations was a cross-border insolvency protocol, which forms part of the court order, which was passed by the NCLAT in the Jet Airways case. So from a cross-border perspective, I believe that Jet Airways is a very significant case because the order which was eventually passed and the settlement terms which were eventually agreed between the Dutch administrator and the resolution professional in India drew upon the principles of the UNCITRAL model law, and a resolution to the dispute was arrived at in an amicable manner. Then the next case is that of SEL Manufacturing, where there were concurrent proceedings which were pending in US and India, and significantly, the US bankruptcy code was of the view that the center of main interest of the debtor is actually in India. And then last but not the least, there is a recent ruling of the Honorable Delhi High Court in the case of Toshiaka versus Vipin Kumar Sharma. In this case, in a proceeding which was initiated by a Japanese bankruptcy trustee in the High Court, a stand was taken by the bankrupt who was an Indian, that this petition is not maintainable. However, the Honorable Delhi High Court recognized the principles of comity and rejected the application and said that applying the principles of comity, we have to give due recognition to the order which has been passed by the Japanese bankruptcy court. So these are broadly the 5 cases which I thought it would be good to highlight to the audience because these are significant cases where, by way of judicial evolution and judicial intervention, cross-border issues have been addressed and solutions have been arrived at by the cooperation of various stakeholders. So yes, So I think that's about it. I do wish to add that as of now, while we don't have a comprehensive framework governing cross-border insolvency issues, however, there are talks which are currently ongoing. The government is deliberating on this. In fact, just before the general elections, there was a 100-day agenda which the government had circulated, which they intended to implement upon post the general elections. And one of the points significantly, which was a part of that agenda, was the adoption of the model of on cross-border insolvency. So as we speak, we do understand that this is one of the upcoming reforms which probably should happen sooner rather than later, apart from various other issues such as group insolvency and other processes of restructuring which the government is currently looking at.
Thank you so much, Mahima ji. It's a wonderful session. I think we got so much of information with such a comprehensive presentation. So I'm really grateful to you and your team for this informative session. I request all our members and guests to post your question in Q&A box, please. Presently, we don't have any question, but I request members, if you have any questions, kindly post the question in Q&A box, and we can request Mahima ji to clarify your queries. We'll be sharing the presentation, which you have just now seen the presentation. We'll be sharing with you, and we will share the contact details, the email ID of Mahima ji and her team, so that in case if you have any questions that you like to ask directly, then you can write to them or you can write to us and we can forward to Mahima ji. So there is a question. Should I read that?
So I'm going through
Singapore
it.
company is holding. Yeah. Singapore company is a holding company till March.
This is a very fact-specific question. I'd be very happy to connect with Srinivas-ji separately on this.
Yes. So I'll request you, Srinivas-ji, in case if you
I'd
like to connect with Mahima ji
directly on this,
yeah,
because
and
maybe certain further facts that I may require from you to address this. And for the audience, I mean, feel free. You need not limit your questions only to cross-border, because I do understand the limitation, because till date we don't really have a cross-border comprehensive regime in the country. So if there's any other question which is pertaining to the insolvency and bankruptcy code itself, we do have time, so I would be happy to address that.
I'll just repeat that we'll be sharing the PPT and the contact details in a day or so, and we'll also share the recording of the session. My request is, in case if members would like to ask any question during this session, kindly post in the Q&A box, please. I think the subject is where the more details are required if they need any guidance and all that.
So, Shikha Garu, the issue is that because there has been, when the report came out in 2018, then there was a lot of discussion around it. And both the reports are worth reading. Whoever is interested in understanding what exactly is being discussed, it's a very well-written report, both the reports actually. And in fact, the second report contains an entire typology of cases. What are the kinds of situations in which an Indian entity can find itself either as a creditor or as a debtor, whether it is with respect to their assets or liabilities, or whether they owe debt to some foreign entity. So these are the kinds of practical situations which the committee has actually gone into, identified, mapped it, and then recommended rules and regulations which can actually address these situations. Now, I didn't want to make the presentation very technical, but I would definitely suggest that the audience, if they're interested in this area, they may want to go into and read both the reports. But yes, as you rightly said, that because this is an area where we are still awaiting action from the government side and hoping that eventually we will have a model law which governs various aspects of cross-border insolvency. Until then, I think maybe the questions will come up as and when the enactment of Part Z happens and it is integrated into the code.
Right. There is a question: what if COC do not give 66% vote to the resolution presented by IRP?
Right. So thanks.
Does the
Shraddha.
company have to?
Yes, I saw
Shraddha,
that.
yeah.
So yes, 66% is a minimum requirement for voting on a resolution for the approval of a resolution plan. And typically, if the COC fails to approve the resolution plan within and the CIRP period is either nearing expiry or it has expired, then there is no other option to the insolvency professional but to file an application for liquidation of the company. But what also happens is that we've seen that in cases where the COC is not in receipt of has received resolution plans, but the resolution plan has not been found to be satisfactory to the COC, then in a lot of cases, the COC can start another process and have another round of invitation of EOIs. And interestingly, now with recent amendments in the CIRP regulations, the RP can also invite invitation for EOIs for certain parcels of assets if the company as a whole is not receiving a resolution plan. So a lot would depend on how much time is left in the CIRP, how much is the COC inclined to resolve the company. In some cases, there may be nothing left in the company. It's barely like a defunct company, and therefore there is a very negligible chance that a resolution plan will either be received or a satisfactory resolution plan will be received. Then in those cases, if the COC doesn't approve a plan and does not want to go ahead with another process, then the RP does not really have any option and she or he has to go ahead and file an application for liquidation of the company. Shraddha ji, I hope that addresses your question.
Thank you. Ms. Srishti has raised the hand. So I request if you can post the question in Q&A, which is possible for you. Or what I'll do is I'll just 1 minute.
We do have time.
Yeah.
So I think.
Yeah, Ms. Srishti, I have
taken
the audio thing.
I have just taken the liberty of just asking the audience, because a lot of times they have questions around the code itself rather than cross-border insolvency issues, because on a day-to-day basis, the domestic insolvency is something which is of more concern to us. So if there's any other question pertaining to the IBC that the audience would like.
Yeah. Srishti, I have raised a hand. Srishti, I have allowed. Yeah. Please, if you like to ask question. Your audio is on, please, if you like to ask.
Hi, Mahima. Thank you for the session. My question is, in terms of issues relating to, shareholdings or, the parent company being a foreign entity and the subsidiary being the Indian entity undergoing CIRP, what exactly would be, so basically the shareholders are the foreign entities.
What would their treatment be under the code?
No, the treatment under the code is clear, but in terms of the AGMs and the decisions that are being made during the CIRP process, what would be the procedure that the RP is supposed to follow? So
what usually happens, Shrishti, is that when the company is undergoing CIRP, then the RP is duty bound to ensure all the compliances. So, whether it is, so when it comes to when you asking about the AGMs. So what we typically see is that because the powers of the board are suspended, however, that doesn't mean that the IRB will or RB will not continue to comply with the extant laws. So if the Companies Act requires the adoption of financial statements, holding of AGMs, etc., that is something that we see that the RB, because the RB is actually acting as the interim board of the company, the RB will convene the AGM, and that is open to any shareholder, whether a domestic shareholder or a foreign shareholder, to attend. And depending on the voting or the AGM, the financial statements, etc., can be adopted. So it does not really make a difference that you are a foreign shareholder or you're a domestic shareholder in the corporate debtor which is undergoing CIRP. If there is an AGM which is being conducted, then equally like a domestic shareholder, a foreign shareholder can also participate in the AGM. But as far as the rights of the foreign shareholder is concerned, we are all aware that there's a particular waterfall which is provided in the IBC, which is section 53, in which the shareholders actually fall quite low in that payment waterfall. And most of the times, whatever payment happens either in resolution or in liquidation, the payouts actually get exhausted at the level of maybe the secured financial creditors, or sometimes the unsecured financial creditors also get something. And usually the shareholders practically don't really receive much unless, of course, the resolution applicant proposes to pay something to a shareholder. Thank you.
Any other question? If you like to post anything, or if you like to raise your hand. Okay, I think maybe if members would like to directly speak to
yes,
you
I would
regarding,
also like to
sometimes
add
they have confidential.
Yes, no. So that's what I was
policy.
coming to, that it is quite possible that members do have questions, but because there are facts which sometimes you don't want to discuss in an open platform. My details are there,
Right.
there on the website. It's also there in the PPT. We'll be very happy to connect and address any queries that any of the members may have.
Sure, sure.
Not just on cross-border insolvency aspects, but also on any other aspect pertaining to restructuring and insolvency or the IBC. So feel free to connect as and when needed.
Sure, sure. We will also circulate the presentation and your contact details with our members, so that in case if they need any professional help, they can directly get in touch. So
Sure.
Thank you so much for this very informative session. Thank you, Mahima-ji, and thank you, Samriddhi, and to all your team members. We'll be happy to have another session with you shortly in future.
Sure.
And thank you to all our members and guests for attending this.
It need not be on cross-border.
Sure.
We'll be happy to have any other session.
Sure, sure. No. We'll take advantage of your other expert areas.
Of course, we'll be very happy. It's always good to connect with the industry members. So thank you for the opportunity.
Sure. Thank you, one and all. Thank you.